I'm Geene Delaplane. I'm the Kinship and Guardianship Program Manager for DCYF. I also want to give you a little disclosure in that my household has COVID, including me. And so we're going to do the best we can, but you're going to see me drinking a lot because my throat is just really raw. Um, so like we said earlier, I'm going to go through a presentation. I would encourage you to jot notes to yourself about any questions you may have through the presentation. Once I get through my slides, then we will double back and do questions and answers. So, and then somewhere in here, I also, yeah. Okay, so I'm not even going to look at chat until we get to the very end. So let's get going. And my whole hope today is to get you through, answer all your questions about guardianship. So let's start with the basics. So we have been moving into what we call a kin first culture for a while now, but there have been some initiatives, more so than others, that have had a lot of impact on guardianship and kinship care. Starting back in 2019, we saw the passing of the Uniform Guardianship Act, and that removed the non-parental custody and created Title 11 guardianships. Then we saw in 2021 child-specific licensing. So that was licensing specific to kinship caregivers. We saw the 1227 Keeping Families Together Act in 2021. In 2022, we saw Pathways to Keeping Families Together, which was really about expanding our gap to Title 11 and reminding us that relatives are the priority for placement. And then last year, we had Supporting Kin, which created a state-funded guardianship program and broadened the ability to use VPAs. So that kind of like sets the stage for everything and why we have so much going on in guardianship world. So let's start with the basics. So what is guardianship? Well, in the state of Washington, we have actually two types of guardianship. We have guardianship of a minor and the guardianship through a dependency. And basically, ultimately, they really are kind of the same thing when it gets down to the nuts and bolts of it. But a guardianship is just simply a legal arrangement. It's when the court says you are now able to make decisions for this person, usually a child, but in the Title 11 world, there are also adults, and that the guardian takes on a legal responsibility to that person. And they are legally responsible for acting in their best interest. And so that's generally what guardianship is. So let's first talk about guardianship of a minor. And you'll see up here in the little corner I put in purple, you will see the bill that I tried to always put the bill number that created all of this along with the RCWs for references. So guardianship of a minor, Chapter 11, you will hear me refer to it as Title 11. That's my my pet name for it. I call them Title 13s and Title 11s. And so Title 11 came into effect January 1st, 2021. It replaced that non-parental custody order. In fact, if you had a temporary non-parental custody order that wasn't finalized, you really don't have a legal document for the child then. Because they didn't grandfather it. You either had a completed non-parental custody order that was finalized or you had nothing. So the guardianship of a minor, it's established in Superior Court. The local court rules apply. What I always find most interesting about guardianship of a minor was it came out of something called the Uniform Guardianship Act. And the idea was that there was going to be a uniform process, but that didn't quite happen. Local court rules apply. And then it's important to keep in mind that a Title 11 may be eligible for a gap subsidy if they meet all other eligibility requirements. And I cannot say this often enough because people always ask this question, but what if we don't have a dependency? There has to be a dependency for you to be able to access the gap subsidy. And then at the court has to find that it's in the best interest of the child and the parents agree, or the parents' rights were terminated, or no parent is willing or able to perform parenting functions. That's what has to be found in order to have a Title 11 guardianship. Okay, so now let's take a look at the different types. There are technically 4 different types of guardianship of a minor. Remember, this is still Title 11, outside of dependency court. This is local superior courthouse, right? So I always start with standby, which is all the way over to the right. The standby guardianship is the one that I think we see the very least of, and that is, think of it as like if somebody's going to be deployed and they want to have somebody that's there in the wings just in case they get deployed or have to go do something. That's what a standby guardianship is. It's literally like you're standing waiting in case you're needed. The ones that we see the most of at DCYF is immediate, emergency, and then guardianship of a minor. So I'm going to start with immediate. The immediate sounds exactly what it is. There is something right now that cannot wait, and because the child is at risk. And what happens is that gets filed on the ex parte docket. It's heard the same day that it's filed. Typically, it's heard the same day that it's filed. Sometimes it takes 48 hours, but typically it's heard the same day that it's filed. But then you have to have the emergency guardianship hearing follow-up within like so many days. Typically, it takes about 5 days to get onto the calendar if we have an immediate guardianship. So that's one type. Then there's the emergency guardianship. We see this a lot. This is just simply a temporary guardianship for the minor. The whole point behind it is it will likely prevent substantial harm to the health, safety, or welfare of the minor. And this is always very important. And no other person appears to have the willingness or the authority to act on behalf of the child. Takes about 2 weeks to get on the docket for this when you file it. It really depends upon your local jurisdiction, but it takes about 2 weeks. These are temporary. They last for 60 days and they can be extended once. So it's a max 120 days with an emergency guardianship, and then they end. Then the idea is during that 120 days, you are working on guardianship of a minor, which is, I like to affectionately call the full meal deal. This is the full guardianship of a minor, much like our Title 13 guardianships that we see through dependency. And again, one of the following has to be true for this, but mostly it's that last bullet. There is clear and convincing evidence that no parent of a minor is willing or able to exercise parenting functions as defined in the RCW. That is what the judge is looking for. I don't know how many of you have gone through this process, but the folks that I have talked to, the grandparents that I've talked to, say this process takes at least a year. If people don't agree, because it's a complex process and it's not easy, but it can be achieved. And there is also support out there for folks to go through these different ones. Probably your best resource would be an agency called LARC. And I will drop that into chat for you later. LARC is a free legal service. You will actually be connected to attorneys who can answer your questions. And then you should also know that at each courthouse, in the superior courthouses, they have, sometimes they change the title of them, but they're basically family law advocates who can help a person fill out the right paperwork for guardianship. They're not going to give you legal advice. They're not going to tell you how to answer the questions, but they will point you to the right forms and make sure the boxes are filled in. And they'll help with that. They usually charge a small fee for that. Okay. Title 13 guardianship. So Title 13 guardianship went into effect June 10th, 2010. I know it's a long time ago, right? Prior to that, we had what we called dependency guardianships. And those guardianships, the dependencies were left open once the guardian was appointed. And that's why we called them dependency guardianships. We are at the very tail end of those. There's like 2 left in the whole agency. And those are kids that are on extended guardianship assistance subsidies. So this is phased out, and now we have what we call Title 13 guardianships. To qualify for a Title 13 guardianship, you have to have an open dependency, has to be in the best interest of the child. Generally speaking, the guardian has to be 21 years or older, have a home study that approved home study that recommends placement. And they also may be eligible for the GAP Assistance Program as long as they meet all the other eligibility qualifications, and we're going to get into that later. And then what they're trying to show is that guardianship is the legal status in which the parent's rights to exercise physical and legal control over a child are suspended, and an appropriate individual, a guardian, is appointed by the courts to fulfill the parent's responsibility. So that's the general landscape of the 2 guardianships. And I know, clear as mud, right? So let's dig into it just a little bit more. Ooh. But first, I know that you guys are probably familiar with this. Senate Bill 1747 required DCYF to talk about guardianship as an alternative to terminating parental rights throughout the life of a case when a child or youth is in our care. So what does this mean? We're required to have a conversation about guardianship. What it means is staff, DCYF staff, are required to do concurrent planning. We have to anticipate, we have to prepare for alternative planning. We talk a lot about this now. We have to talk about it in permanency planning meetings. We talk about it one-on-one with the caregivers, with the parents. It gets talked about quite a bit. Having discussions about guardianship as an alternative to terminating parental rights. Okay, so what do we talk about? We talk about Title 11, we talk about Title 13, and we talk about GAP subsidies. Well, we're trying to get folks to think about guardianship as either subsidized or unsubsidized, I think is the way we're trying to frame it a little bit differently right now. But these are the things that we have to talk about. And then the things that we use to talk about these is the permanency planning matrix, and we use our GAP subsidy specialists. We also call them the GAP gatekeepers, guardianship gatekeepers. We have a couple of different names. At the end of this PowerPoint, I will have a list of all of your regional gatekeepers that you can reach out to when you have specific questions, or you're really more than welcome to reach out to me too. But we have to talk about the types of guardianship and why this would be an alternative to terminating parental rights. So when we do that, how do we do it? So this is a great comparison of Title 13 and Title 11. So throughout this presentation, the Title 13s, the ones that are done through the dependency process, are in light blue, and then the darker blue is guardianship, and that is the one that is done outside of in a superior courthouse. So I'm going to walk you through each one of these sections to kind of help you get the gist of the difference. So we start with what type of law is it? And the Title 13 guardianships they have to have an open dependency case. And so it's a juvenile law and it goes through juvenile court. And then the Title 11 is under guardianship. It's technically a conservator law. And so there's a lot more to it than just minors. So it's also about guardianships for adults. And then who can file the case? In a Title 13, anybody who is a party to the case can file. So that's the state, the parent, the dependent child, if they're 12 or older. Those are the folks that will file the 13 guardianship. Title 11, it goes to either the child who is seeking a guardian, a person who wants to be the guardian, or a person who believes the child needs a guardian and is helping somebody else become the guardian. And then again, where's the case filed? The 13s, the ones through DCYF, are filed in juvenile court in the county where the dependency case is already open. Whereas if you're doing a Title 11, it is through the Superior Courthouse in the county where the child lives. Although there is some discussion that it could occur through dependency court, but nobody has ever tried it. So then what has to be proven? Under the Title 13s, it has to be in the best interest of the child to establish a guardian rather than terminate parental rights and proceed with adoptions. And then the Title 11s, like I said earlier, the court is looking to find that a guardianship is in the best interest of a child and the parent agrees or is willing, or the parent's rights have been already terminated, or no parent is willing or able to perform the parenting functions. So does the guardian need to complete a background check? In the Title 13s, the time we get to finalizing to guardianship, they're placed with their caretaker, and DCYF has run the background checks, we've done suitability assessments, we've done probably a home study at this point. I mean, we've already done that. So when does it happen in the Title 11 cases? Well, it depends upon which one we're talking about. So I'm going to start at the I think of it as the bottom of the hierarchy. So immediate and emergency guardianship cases, all the court does is check what they call the JIS system. It's a judicial information system for anything that might be relevant to child safety. That's all that happens. But when they're doing the full guardianship, then one of the very last steps that occurs when doing that type of guardianship is there is an order sent over to DCYF that says, please run the background check and character suitability. And we do that once we get the order from the courts. Does Indian child welfare rules apply to both? Yes. In both types of guardianships, ICW applies. Do parental rights get terminated in a Title 13? No, it is not required to terminate parental rights. Although I want to be really clear with this, because of the new rules, we are seeing kids who are legally free go into guardianships. And so it doesn't mean that it can't happen. It's just not the norm. So in a Title 11, parental rights are not required to be terminated. I want to say to you, what I'm about to say is probably the biggest difference between the two. So full authority can be granted to the guardian, but because this is also, if you remember the name of this, it's also called limited guardianship of a minor. Limited really means that in some cases, the judge will say to like the aunt, I'm going to grant you guardianship of this child, but the parents are but your rights will be limited and the parents will retain rights to make education decisions. We do see that happening. And then another big difference is child support. In Title 13s, we do not collect child support. We just don't. But Title 11, the judge certainly can and does order child support to be paid by the parents. Terminating the guardianship. This is everybody's biggest fear, right? Terminating a guardianship. So what I will say to you is when I started this position a couple of years ago, there were very few terminations, but we are now seeing more and more. And so when I say more and more, I'm seeing, maybe 4 to 5 requests to terminate guardianships that go through the courts. But what I want to say to you is the why is something. So I've only actually ever seen 2 guardianships terminated because the parent has gone back into court and said, I have remedied my parenting deficiencies and I would like to have the child back. And so, and it's very complicated when that happens. And oddly, DCYF is not a party to the case. We get notified about it, but we're actually not a party to the case. I've sat in on these before just as an observer to see what goes on. And the judges really impressed me. They really put the parents through the hoops, and they have to prove, this is why you're parenting, this is why the guardianship was established. Show me what has changed. And in the ones that I have seen come through the courts, the guardian and the parents actually agreed. And so, but what was really interesting in the one case was that it was the dad. He had really gotten his act together. He had been clean and sober for 6 years. He had visits with his kids. I mean, he was doing really well. The guardians were getting older. The kids were spending more and more time with the dad. And he was like, why don't we just return the kids to me? Ultimately, they did return the children to him once he established a parenting plan with the mom who had not gotten her act together. And the judge was very diligent about making sure the child was safe. So it's not so easy. So now you're wondering about, well, what are the other terminating the guardianships? If you have a gap agreement, sometimes not sometimes, we always have what we refer to as a successor guardian. A successor guardian is somebody who kind of hangs out in the wings just in case something happens where the guardian becomes incapacitated or unfortunately passes away. And then, so we have been actually seeing a spike in successor guardianships coming forward and going through the process of becoming guardianship, and then the gap agreement transfers to them. But back to terminating the guardianships, the 11s. So the guardianship can end when the court finds that the reason for the guardianship no longer exists, unless the court makes 2 findings. So they end the guardianship. Ending the guardianship would be harmful to the minor, or the minor's interest in the guardianship continues to outweigh the interest of the parents. The thing about guardianships, Title 11 guardianships, is what is possible is that they can be created just because everybody agrees. But if there's no stipulations put into the petition about maybe the parents participating in treatment, or they have to be clean and sober or something like that, there's actually nothing that really has to be proven to undo it. So it's a little bit trickier. It's a little bit easier to undo a Title 11 guardianship than there is a Title 13. And undoing a Title 11, I would say to you, well, even a 13, you really just need to consult with an attorney because they're both pretty complex processes. Oops, my thing went the wrong direction. Okay, what about financial support? Everybody always wants to know about this. So in Title 13, the answer is yes. There is financial support available. You have to be a licensed foster parent at the time the guardianship is established, and the child has resided with the proposed guardian post foster care license for a minimum of 6 consecutive months before the guardianship is established and eligible for a gap subsidy. You'll hear me say this so many times today. If you're considering a guardianship and you're in the process of negotiating a gap agreement, do not finalize the guardianship until the gap agreement is signed by yourself and the agency. Because if you don't, then it creates all sorts of problems and you might not be able to receive a gap subsidy. In a Title 11, yes, it is possible. We've only seen one in the last 2 years. There has to be an open dependency. They have to meet the same eligibility standards of the Title 13, and they have to have a full guardianship. It can't be an expedited or an emergency. Okay, guardianship as a permanency plan. So let's talk about Mythbusters. I know that people get nervous about this right now because it kind of feels like the agency is spotlighting guardianships. And so I get asked these questions, and I like to call this my Mythbuster section. Does the age of the child matter in a guardianship? And the answer is no. The age is not a consideration. DCYF can only do guardianships. No, we do adoptions. It's whatever is in the best interest of the child. Is one permanency plan better than another? I get this question a lot. Which is better, adoption or guardianship, adoption or guardianship? There is no hierarchy. It's not adoption versus guardianship. It's adoption and guardianship. And then which would be better for the family to complete? Title 11, Title 13. And I will tell you, and everybody will tell you, you should probably consult with an attorney because we cannot make that decision for you. Okay, let's talk about should a guardian become licensed? And this is where I have to remind you, we do concurrent planning, right? Concurrent planning means having plans A, B, C, D, E, and F, all the way to Z sometimes. But we have to be doing concurrent planning, especially if we're thinking about a gap subsidy, because to have a gap subsidy, you have to have been licensed and received foster care maintenance for 6 consecutive months prior to closing the guardianship. So when you think about the amount of time it takes to become licensed and you start engineering the math on that, it's really important that we start talking about this early. So why is it beneficial to become licensed? Okay, I hate to say this, but it has a lot to do with money. You can receive a lot more money to help support the child in your care if you are licensed versus if you are receiving just a child-only non-needy TANF grant. So let's dig deeper into this. So DCYF, one of the initiatives that I talked about early on was House Bill 1227. And within it, 1227 did a lot of things. And I know people have a lot of big feelings about 1227. But one thing 1227 did do was create the initial licenses. Love the initial licenses. And in fact, at some point, I'm going to drop into a link for you on the a one-pager that helps explain the process. But the initial license is just that. It's a child-specific for a relative or a suitable person. Basically, if you're an unlicensed caregiver, think of it as a driver's permit. This is how we like to frame it. It's not like a real foster parent license. It's like a driver's permit. It is provisional, 90 days, maximum, total maximum. There has been discussion and attempts to make that longer, but the legislature has not been receptive to that. And because it's in law that it is a maximum of 90 days, it will take a change in the law to be able to extend it. So 90 days is all it is. Minimal placement requirements, and those minimal placement requirements are, we do a codex of everybody 16. Codex is a background check on everybody 16 and above in the home, and a walkthrough, and then we do our normal placement paperwork. Those 2 documents are all that is necessary for an initial license. And again, it is non-renewable. So this is what the map looks like in the publication. So if you look at the steps, you will see that the first thing happens is that the caseworker identifies a caregiver, and the caseworker works to gather the information that the background unit is going to need to run the background check. And then the background check completes the process. The child welfare worker does the walkthrough of the home. Child welfare worker is also having a conversation about the initial license and TANF, and I'm going to get to that in just a second. And then the child welfare worker also will complete a placement agreement with the caregiver. During all this time, when everything is, and then we place the child. And so then what's happening during this time is the caregiver is deciding whether or not they want to move forward with the initial license. You don't have to get an initial license. It's totally optional. But if they want to go forward with the initial license, then they need to cooperate with the case planning, the home study, and the licensing process, and we try to get it done in 90 days. It can be done. And so, but if they don't, then an initial license isn't issued, but they still have to go through the home study process, and they can reach out and get non-needy TANF. So then it used to be that the court had to order DCYF to commence with the initial licensing. Technically, the court can still do that, but it's actually not required. After that, the caseworker continues with just normal case activities, health and safeties and services and stuff like that, while the caregiver continues to work with the background unit to complete fingerprinting. And then after that, and this is like a very short period of time, right? And so now, 10 days later, the licensing department receives notification within 10 days. They verify that the caregiver wants the license, and that there's a couple of pieces of paper that have to be uploaded into FamLink. But then licensing will launch the initial license, and ta-da, it's there. And then the caseworker remains the caseworker through the licensing process with the caregiver. And then LD assigns somebody to it, licensing assigns somebody to the caregiver to help complete the full licensing process. We refer to that as the kinship license, and then which is a full license. And then after that, it takes a little bit of time to work through it, but hopefully it's done within that 90 days and we're fully approved. Now, if there's any hiccups along the way, we have to let the courts know, because that's how it reads in the RCW, is that we have to let the courts know if there's anything that's that prevented the licensing. But I'm not aware of any that has come up. And then again, this is and yes, this will be available for you guys. This is the link to the publication. It's called the Initial License Publication, and it helps explain everything. Okay, let's look at the numbers. Licensed versus unlicensed caregivers. Why? So first off, let me say to you, many of you may be familiar, there is a new foster care maintenance rates that went into effect January 24th. And so this is the new rate table. You will see, just so I can help you read this, see the level 1, and it says basic maintenance foster care. This is for the initial license category for ages 12-year-old and up. Once you get fully licensed, it goes to $1,200. Anyway, a non-needy TANF grant, they also have new rates. They just went up. And so for one child, it's $450. And then it goes up about $120 per child after that. As many of you know, the non-needy TANF grant doesn't give you $450 per child. It goes up by $120. Whereas if you are a licensed foster home, and my example, I always lowball it, is if you have a family of with 3 children who have been placed with you. And I used, like, they're all under the age of 5 for the purpose of my math. So that's $722 per child. That equals $2,116 a month that comes into your home, as opposed to receiving non-needy TANF, which is a total of about $706 when I did the math for the 3 kids if they were on a non-needy TANF grant. So I told you we needed to talk about non-needy TANF, and this is where we talk about it, and the initial license. The initial license is fabulous. Its entire purpose was to get money into the home quickly. However, it actually takes a little bit of time to get the dollars into the home. And the reason is because it's a reimbursement. And it's a deliberate that we do it as a reimbursement, because when we reimburse, there's no tax form issued and you don't get taxed. Whereas if it's paid immediately, then it becomes taxable. And so there is a reason and a rhyme behind why we do this, but that's the general why. So how do we get to all of this? Like, I've talked to you about a ton of stuff so far, but how do we actually make decisions? And so the way we do this is we have shared planning meetings, and we talk about what's in the best interest of the child. We talk about all the permanency options. We talk about return home. We talk about adoption. We talk about the 2 types of guardianships. We talk about extended foster care if that's appropriate. We talk about all of those. We're also having conversations with the parent and the caretaker about guardianship as opposed to adoption. We are required to, under the RCW 1334, requires us to really rule out guardianship. Why not guardianship? And the answer of because it's not as permanent as adoption is actually not a reason that the courts consider. There has to be more to it. Then we talk about the 11 and the 13. We talk about when permanency is achieved, DCYF is no longer involved in the case. And we also talk about how we continue to look for relatives throughout the entire length of the case up until the time that permanency is achieved. And then we decide on a plan. Okay, let's talk about subsidized guardianship. So this is the GAP program. And there's been a lot of changes to the GAP program, but we'll start simple. So first off, the Guardianship Assistance Program, and you'll notice it's called GAP now, as opposed to RGAP, is a subsidized guardianship. And so what is the subsidy? The subsidy is a monthly cash payment that cannot exceed 80, 90, 95% of the foster care maintenance level. And then there is the opportunity for a one-time non-reoccurring cost at the very beginning. And the whole purpose behind that is to help with any legal expenses that are associated with achieving guardianship. And then the subsidy also includes they're eligible for Medicaid. So it's the same foster care health insurance that they were receiving while in our care and authority. That just continues through until they're 18, and in some cases can continue until the age of 21. They're eligible for in-home evidence-based programs, services, but to access them, you have to go through FVS, Family Voluntary Services, or FRS, Family Reconciliation Services. The way you do that is you call in an intake and you request the services. The kiddos might be eligible for some college benefits, very similar to adoption. When you do your FAFSA, it'll ask if you have been a ward of the court. And when you get into the details of that, it will tell you, when you look in the guides, it will tell you that they consider guardianship the same as they do adoption. And then they are eligible for a child tax credit. Sadly, the subsidized guardianships are not eligible for that big adoption credit, but That's for adoptive parents. Okay, so when we talk about the monthly subsidy not exceeding 80, 90, 95% of the foster care maintenance level, this is what we're talking about. These are our new levels. And so let's pretend you have a 14-year-old and your 14-year-old doesn't have any other issues. Then you are going to see $1,202.50 each month to care for this child. And then if you go into having a subsidized guardianship, the top rate would be right around $1,100 a month would be what you would continue to see for your gap subsidy. Now, if things change, and so let's say your kiddo who had no issues all of a sudden have developed some mental health issues, I would encourage you to request a modification to your gap agreement, and that way we can see if the rate would go up. And so you can see if it was $1,200, it would go up to $2,500, and again 95% of that. So it just depends upon on the needs of the kids. And I'll just say briefly, so foster care maintenance levels, just so you guys are aware, are based on RDA data. I'm sorry, I can't remember what RDA means, but it's medical information. And so when kids are in care, DCYF can pull down their RDA data, which tells us what their diagnoses are. And based on those diagnoses is how your level 1 through 7 is chosen. And then if you already have a gap agreement and it was based on the old rate, you can request a modification to that agreement. You would just reach out to the gatekeeper in writing and say, I would like you to take a look at this to see if there's any, I would like you to have a redetermination based on the needs of the child. And then they would send you paperwork and we would start doing that to see if you would be eligible maybe for a higher rate. Okay, this is the actual legal RCW definition of who is eligible for subsidies. I put this in here because I think it's important for people to see it. It says very clearly, any guardian who is a foster parent pursuant to the RCW at the time a guardianship is established under this chapter, and who's been the child's foster parent for a minimum of 6 consecutive months preceding entry of the guardianship order is eligible for a guardianship subsidy on behalf of the child. The department establishes rules, eligibility, application, and program standards that are consistent with federal guidelines for expenditures of state and federal funds. And we have a whole set of policies and procedures that are out on the web that people can look at. And then a child is eligible when a child has been placed at least 6 consecutive months with a guardian who has been licensed for 6 consecutive months, or the child is placed with a guardian who is already receiving a gap subsidy for the benefit of a child's sibling. And then a child need not be eligible for federal foster care reimbursement in order to qualify for the state funded. This was the beautiful language that went in that gave us the state funded guardianship program. And then, of course, nothing in this section construes to be an entitlement. So what does all of that really mean? Generally, a child has to be in an open dependency. There has to be a permanency plan of guardianship, which has been determined in the best interest of the child. The youth or the child has to be placed with their fully licensed foster parents for 6 consecutive months post-licensing. And if the child is 14 or older, they have to agree to the plan of guardianship. And while you did not see that in the RCW, it's actually a federal rule. Okay, remember what I told you? I'm going to say this over and over. It's really important. If you're going to do a subsidized guardianship, timing is everything. Do not pass go. Do not collect $200. If you are negotiating a gap agreement, you have to sign it before the order is finalized for the guardianship. If not, you might not receive it. So just keep that in the back of your mind. Okay, so let's talk about, what about all those non-subsidized guardianships? Who are those folks? Well, basically, a family is not eligible for GAP pretty much for one reason and one reason only, and that would be they have failed to become licensed. Possibly because the child isn't in a dependency, but basically because they have not been willing or able to become licensed. But a family would still be eligible for the child-only TANF grant. And as I showed you earlier in that earlier slide, it's at a significant reduced rate compared to what foster care maintenance is. And you're able to apply for Apple Health. Okay, best interest of the child. And I know people have a lot of thoughts about this. So the RCW says the best interest of a child custody decision should be taken into consideration the living situation that would most likely give the child or the children the healthiest, most emotional, secure, and loving outcome despite of the separation of their parents. So how do you come to that? It takes a lot of discussion. Sometimes you weigh into consideration services and subsidies that you can receive on behalf. And how do you make those decisions? So what I will say to you is, first off, I'm not going to go into this at all. And I know you might be disappointed in that, but it's mostly because what you're hearing tonight is about guardianship. You're going to hear from Lindsay in a few weeks about adoption. But then you're going to hear from the two of us on a pretty extensive comparison between the differences between guardianship and adoption support and the array of services that could or could not be available. Generally speaking, and this is very general, medical and dental benefits are the same between a subsidized guardianship and adoption support. It's the exact same insurance. The training that is available to the caregiver, the adopted parent, is the same. The reimbursement for non-reoccurring adoption expenses, remember that's the non-reoccurring is the legal expenses that you might incur while trying to go through adoption or guardianship. For adoption, it's $1,500. For GAP, it's $2,000. I don't know why the federal rule made them different. They just did. And then pre-authorized counseling and access to services is different. With the adoption, you do have pre-authorized counseling. You do not have that with guardianship. You can access it using your medical, but it is not pre-approved counseling slots like adoption has. But then the monthly cash payment is based on the exact same calculations. 80, 90, or 95% of the amount of the foster care maintenance. And the 80, 90, and 95% is based on the child's age, is where that comes from. And so when you look at it like that, they're very, very similar. And that's been deliberate. What I will say to you is, probably in May, I think it's going to be in May, we will have a very detailed one that really walks you through the differences for all sorts of things to consider. But for tonight's purpose, this is as far as I'm going to go. Okay, now let's talk about what changed recently around guardianship subsidies. In July 23rd, to be exact, 2023, Senate Bill 5124 went into effect. And what did it do? It changed the name of the program from RGAP to GAP. So those of us that have been around for a bit, we're struggling with that little R, and we still refer to it as RGAP, but it is called GAP. And then the eligibility criteria changed. The extended guardianship program eligibility criteria changed. And then GAP and extended guardianship subsidies for kids in tribal jurisdiction, under tribal jurisdiction, also changed significantly. So let me walk you through the changes. First, I get this a lot. This is probably the biggest change is, can a suitable other person or a general foster parent receive a GAP subsidy? And the answer is yes, if all eligibility is met. So meaning they're a licensed foster parent and they have received foster care maintenance payments for 6 consecutive months post-licensing for the child the guardianship is for. If that occurs, then a suitable person and a general foster parent now can receive a GAP subsidy. We refer to it as the state funds. And I know that, so we created the state funded guardianship program, but the truth is we don't differentiate. The only person who really cares about, is it state funds or federal funds, are our fiduciaries and our Title IV-E folks when we are doing our federal reporting. For the purpose of general public, general conversations, it's just the GAP subsidy program. Okay, so let's talk about the extended guardianship assistance program. This is one of my most favorite changes. Okay, first off, we've had the extended guardianship program, so does adoption. It's very similar to EFC. So here's what the program is. Youth ages 18 up until their 21st birthday, so we can't go beyond they still have to be 20. Once they're 21, it terminates. May qualify for an ongoing subsidy if they meet one of the 5 criteria. That's what's below on this slide. They're either still enrolled in high school or an equivalency program. They are enrolled in post-secondary, so college or some sort of vocational certificate program. They're participating in an activity designed to promote or remove barriers to employment. That's code for treatment. They're employed 80 hours or more a month, or they're unable to engage in any other of these activities due to a documented medical condition. So if any of these exist, so I always like to use the example of my daughter. When she was in high school, she turned 18 in November, but there was still December, January, February, March, April, May, June, 7 more months before she graduated. Well, the same is true for kids that are in a guardianship. So now if they're still in high school, they can, you can go through the process to become part of the extended guardianship assistance program. Now, the dollars do not go directly to the youth. They, like you would in EFC, the dollars go directly to the guardian. And when you apply to the extended guardianship program, a couple of things occur, and that is both the youth who is turning 18 or is over 18 and the guardian apply together. It's a joint application. And then we also need to see verification every 6 months. The verification can be sent to a new email address that we have. It's called guardianship@dcyf.wa.gov. And then they have to live with the guardian or in an approved supervised independent living situation. We call them SILs. What is a SIL? Generally speaking, SILs are dorm rooms. So like, let's say you live in Kelso and your child that you've had in a guardianship decides to go to UW and live in Seattle in the dorms. They would still qualify for the extended guardianship program because they're still in school and they're in an approved living situation like a SIL. So then this is one of the biggest changes. So this is dramatic. For most of you, this will not really be an important part of the act, but what changed in this was children and youth under tribal jurisdiction are now eligible to receive a GAP subsidy. That was not always the case. It was very, very limited to just tribes that were what we refer to as a 4E tribe, which was very limited. And so now this has broadened it. So what it says now in our in our RCW is that the department, DCYF, can provide subsidies, gap subsidies, to eligible guardians who are appointed as a guardian of an Indian child by a tribal court of a federally recognized tribe located in the Washington state as defined in the RCW. And then to be eligible, the guardian has to be certified, meaning licensed by either the department, DCYF, a child placing agency, a tribal child placing agency, or a federally recognized tribe located in Washington state that is a 4E agency. That would be Port Gamble, McCaw, Quinault, and I'm losing one. I can't think of the fourth one right off the top of my head. So again, this is for kids who are licensed, who are under tribal court jurisdiction. The guardian has to be licensed by either DCYF, a tribal CPA, a CPA, or federally recognized tribe that's a 4E agency. They're not eligible for a gap subsidy if they're licensed by a tribe with an IGA or if the guardian is not licensed. So those are the nots. And then also kids who are under tribal court jurisdiction, the general eligibility rules, much like our eligibility, is they have to be in an open dependency, except the dependency is through tribal court. The guardianship is in the best interest of the child, and the tribe tells us that. The guardian has to be licensed. They have to have been with the proposed guardian for 6 consecutive months prior to post-licensing. And the gap agreement, again, has to be signed prior to finalizing the guardianship. This is a list of all of your gatekeepers. This is the most current up-to-date list. They are all amazing, knowledgeable human beings, and I would encourage you to reach out to them. Like I said, this PowerPoint will be available. And so this is where I say thank you, and I'm going to open it up for questions, because I'm sure